Is a simmering conflict stressing you out? Before you dive into a possibly expensive, drawn-out, and public courtroom battle, there might be a better way. What if you could skip the adversarial fight where a judge picks a winner and a loser? What if there were a faster, cheaper, and private solution for you and the other party craft a custom win-win outcome you can both genuinely live with? In this video, we're pulling back the curtain on mediation, what it is, how it works, and why it might be the perfect fit for your dispute. Let's start by defining mediation. Mediation is an informal, voluntary, and confidential process where a neutral third party, the mediator, helps disputing parties communicate, understand each other's perspectives, negotiate, and reach a mutually acceptable resolution. The 4 pillars of mediation are the key principles that define the process and distinguish it from litigation or arbitration. These pillars are voluntariness, confidentiality, neutrality or impartiality, and self-determination or party autonomy.
Confidentiality is a cornerstone of mediation, designed to create a safe space for parties to speak openly and candidly, without fear that their statements will be used against them later. It is what makes the process non-binding until a formal agreement is signed. Here's a breakdown of what it means in practice. 1. Communications are privileged. Anything said, written, or created specifically for the purpose of the mediation cannot be used as evidence in a subsequent court case or legal proceeding. This includes offers, admissions of fault, settlement proposals, and even the vibes of the session. 2. The mediator is a neutral third party. The mediator is legally and ethically bound not to disclose information from the mediation to a court or any outside party, with very few exceptions. They cannot be subpoenaed to testify about what happened in the session. 3. The process is private. Mediation sessions are not open to the public, and no official record, like a court transcript, is made of the proceedings. This principle allows parties to explore potential solutions, admit weaknesses in their case, and compromise without worrying that these actions will harm them if the mediation fails and they end up in court. There are important exceptions to the rule of confidentiality. 1. The final agreement. If you reach a settlement, the written agreement you sign is an exception to the confidentiality rule. The entire purpose of these documents is to be enforceable and used in court if one party breaches the agreement. 2. Information relayed to the court. When a court orders mediation, the mediator will send a report back, but this report is brief and focuses on the session's outcome, not the details. The report will include the following information: date and time of the sessions, attendance of all required parties and their attorneys, and the outcome: full agreement, partial agreement, impasse, or no agreement. 3. Threats of violence or criminal activity. Confidentiality is not a shield for illegal acts. If a party makes a threat of serious bodily harm or discusses a crime, a mediator may report it. 4. Abuse or neglect. In cases involving child custody or family disputes, mediators might disclose credible allegations of child abuse, neglect, or harm to a vulnerable adult. 5. To prove a breach of a legal duty. In rare circumstances, confidentiality may be pierced to address a claim against the mediator or the mediation program, such as allegations of fraud or coercion during the process. There is extra confidentiality in caucuses. A caucus is a private, individual meeting between the mediator and one of the parties, and their legal counsel, if any. This is a crucial element of mediation and has an extra layer of confidentiality. When a mediator meets with you in a caucus, you can speak even more freely. The mediator will ask for your permission before sharing any information with the other party. The default rule is that nothing you say in a caucus can be shared with the other side unless you specifically give permission. This allows you to discuss sensitive issues, your bottom line, or confidential business information that you would never want the other side to hear directly. Another important note is the discoverability during a trial. This is a critical distinction. While information discussed in mediation is generally not admissible in court, information that exists independently of the mediation is still discoverable. For example, if you admit in a mediation session that you were negligent in an accident, that admission cannot be used against you in court. However, if during the mediation you mention that you have a specific document, like a police report or a receipt that is relevant to the case, that document itself can be subpoenaed and used in court. Its existence is a fact that is discoverable, even though it was mentioned in a confidential setting.
The concept of neutrality in mediation is a foundational principle that defines the mediator's required relationship to the parties and the dispute's outcome. In simple terms, a neutral mediator has no vested interest in how the dispute is resolved and has no prior relationship with the parties that could suggest favoritism. They are an acceptable third party who approaches the mediation with an open mind. For the mediator, neutrality means be disinterested in the outcome. Their paycheck is the same whether the parties reach a deal or not. The substance of the final agreement is determined solely by the parties, not by the mediator's personal opinion of what is right or fair. They are avoid bias or favoritism. They must manage their own feelings, judgments, and potential unconscious biases to ensure they do not take sides, either explicitly or subtly. They must maintain professional distance. They must not advocate for a specific party or position. The mediator's neutrality is vital because it establishes the trust and safety necessary for a successful mediation. For the parties, it means assurance of a level playing field. Both parties can enter the mediation confident that they will be treated equally. Trust and open communication, knowing the mediator has no bias, encourages parties to open up and share sensitive information honestly. 3. Focus on self-determination. Neutrality reinforces the principle of self-determination. It tells the parties that they are the decision makers.
The concept of voluntariness means that participation is based on the free and uncoerced choice of the parties involved. Mediation cannot begin unless all parties willingly consent to participate and attempt negotiation with a mediator. Crucially, any party has the right to withdraw from the mediation session for any reason at any time without penalty from the mediator. A note on mandated mediation. While some courts require parties to attempt mediation before a trial, this mandates attendance, but it does not remove the core principle of voluntariness. The court cannot force the parties to negotiate or reach a settlement. Never to skip court-ordered mediation. You can request an exemption if you have valid reasons like domestic violence, safety concerns, etc. Another critical element of voluntariness is the voluntariness of the outcome. It is linked to the principle of self-determination.
The concept of self-determination in mediation is another foundational principle that grants the parties ultimate control and authority over both the mediation process and its final outcome. It is defined as the act of coming to a voluntary, uncoerced decision in which each party makes free and informed choices as to the process and the final agreement. This principle is what primarily distinguishes mediation from litigation or arbitration, where a judge or arbitrator imposes the decision. For the disputing parties, self-determination is an assurance of autonomy and empowerment throughout the entire process. Parties have control over the process. As previously discusses, parties can choose to withdraw at any time if they feel the process isn't working for them. They can decide which issues to discuss, what information to share, and how the discussion will be structured, though the mediator provides the framework. They must be able to seek information to understand the legal, financial, or relational consequences of any options or agreement they are considering. Parties also have control over the outcome. Self-determination means the parties, not the mediator, must craft the solution. If an agreement is reached, it must be mutually acceptable to both sides. It is important to note that parties are free to generate creative, tailor-made solutions that a court could never order because they are the experts on their own lives and needs. Mediations are not just about money, retribution. They're also about explanations, apologies, trying to repair relationships or properly end them, having a safe, confidential forum to explain your perspective, vent your frustration, and feel truly heard by the other party. For example, in mediation, you can request a positive job reference in exchange for a quiet resignation. You can have a mutual non-disparagement agreement where both parties agreed to a mutual, enforceable pledge not to speak negatively about the other party. Mediation allows you to create a flexible co-parenting schedule or the transfer of ownership of a specific non-monetary asset like a family photo album, a rare book collection, or the wedding video master copy. The court won't order any of these agreements. Note, however, that enforceability of non-monetary terms can be more challenging than monetary terms.
With your new understanding of mediation, the next step is to explore if it's a good fit for you.
First, let's briefly compare mediation to arbitration and litigation. Mediation is very different from arbitration and litigation. The major differences are who makes the decision, the process, control, and confidentiality. What is important to remember about mediation is that the parties are making the decisions, not an arbitrator, a judge, or a jury. The agreement is non-binding until you both sign the agreement. You have control over the process and outcome, and what is said during mediation is not public record.
The top reasons to choose mediation over arbitration or litigation center on control, cost, speed, and preserving relationships. Mediation is a cooperative negotiation, while arbitration and litigation are adversarial processes where a third party, arbitrator or judge, imposes a final decision. In mediation, the parties themselves control the result. The mediator's job is to facilitate communication, not to make a decision. If you don't agree to the terms, there is no settlement. With a mediation, you can craft creative, non-monetary remedies, like an apology, a job reference, or a change in a business process that a judge or arbitrator is legally unable to order. And because the parties create the agreement, they generally have a higher weight of voluntary compliance compared to a decision imposed by a court or arbitrator. Also, the mediation process is typically less expensive than arbitration or litigation. It minimizes fees for attorneys, discovery, court reporters, and expert witnesses that are required in litigation and, to a lesser extent, in arbitration. Also, the mediation process is typically faster. Most mediations conclude in one day or a few sessions over a few weeks. Litigation and arbitration can take months or even years. There are also added benefits of mediation, like its confidentiality aspect and the fact that the process is flexible and informal. More importantly, the nature of mediation helps maintain or repair relationships between the disputing parties.
Mediation isn't a silver bullet for every dispute. When considering whether mediation is the right path, we need to focus on two core concepts: good faith negotiation and fairness. First, let's set aside criminal matters. While forms of mediation are used in criminal cases for restorative justice to help victims and offenders heal, they won't replace the formal criminal justice process or a verdict on guilt. For civil disputes, mediation becomes inappropriate and potentially harmful when those two core concepts of good faith and fairness are compromised. When fairness is impossible due to imbalance, mediation relies on both parties being able to freely and equally advocate for their own interests. It is often unsuitable when one party cannot do this because of a power imbalance. This is why mediation is typically avoided in cases involving a history of domestic violence, physical or psychological abuse, where coercion or intimidation would prevent genuine negotiation. It's also inappropriate when there's a gross disparity in control, such as when one party has a high degree of financial or emotional control, has intentionally hidden assets, or is completely uninformed about the case. 2. When good faith is absent or communication has failed. Mediation is also a waste of time and money if the commitment to the process isn't genuine. It should not be used as a fishing expedition to gather information for court or as a mere stalling tactic. Similarly, if the emotional intensity is so high that the parties are unable to engage in a rational discussion, or if both parties are completely unwilling to compromise, the mediation is doomed to fail. And 3. When you need a formal, binding ruling. Finally, there are times when you need the authority of a third party to make a final, binding decision. This is true for cases that require immediate court orders, like temporary injunctions. It is also often better to go to court for disputes involving major fraud, gross negligence, or major criminal conduct, as these cases often require a formal investigation, a rigorous discovery process, and a public finding of fact that a private mediation cannot provide. You should also choose litigation if your primary goal is to set a legal precedent that affects others, as mediation results in a private contract, not a public ruling. In short, if you can't negotiate freely, can't negotiate in good faith, or your case demands a public and forcible ruling, litigation remains the necessary path.
Mediation offers compelling advantages, primarily because it is a confidential, cost-effective, and fast alternative to court, allowing parties to retain complete control over the process and a negotiated solution. While it empowers you to craft creative, mutually acceptable resolutions and preserve important relationships, the process may fail if the parties are unwilling to compromise, or if significant power imbalances exist, potentially leading to wasted time and costs before turning to litigation.